A new Supreme Court ruling is once again igniting national debate over the Second Amendment, concealed carry rights, and the future of gun laws across America. Supporters are calling it one of the most important victories for gun rights in modern history, while critics warn the decision could dramatically limit how states regulate firearms moving forward. But what exactly did the court decide, and does this really mean people can now carry firearms anywhere in the United States? The answer is more complicated than many viral headlines suggest. What the Supreme Court has done in recent years is strengthen constitutional protections surrounding public carry and firearm ownership by changing how courts evaluate gun laws under the Second Amendment. Instead of simply allowing governments to justify restrictions by arguing they improve public safety, courts are now expected to look closely at America's historical traditions and constitutional text before approving major firearm restrictions. That shift has already started changing the legal landscape nationwide. For decades, several states operated under what were commonly called may-issue permit systems. Under these systems, citizens often had to prove a special need or extraordinary reason before they could legally carry a firearm in public. In some places, self-defense alone was not considered enough. Local officials had broad discretion to decide whether someone deserved the right to carry. Critics argued these systems turned a constitutional right into a privilege controlled by government officials. Gun rights advocates said no American should need to convince the government that they are important enough to defend themselves. The Supreme Court signaled strong opposition to those discretionary systems, and that changed everything. Now many states are moving toward shall-issue systems, where permits are granted based on objective standards like background checks and legal eligibility instead of subjective opinions from officials. That is one reason why many gun owners see the court's direction as a major expansion of Second Amendment protections. But here is the important reality check. The Supreme Court did not rule that Americans can literally carry firearms anywhere they want without restrictions. That is one of the biggest misunderstandings spreading online right now. Even after major Second Amendment rulings, governments still maintain authority to restrict firearms in certain, sensitive places. Courts have historically recognized locations such as courthouses, secure government buildings, prisons, and some restricted facilities as places where firearm restrictions may still be constitutional. The legal fight now revolves around how far states can expand those restricted zones. Some states responded to recent Supreme Court rulings by dramatically increasing the number of locations classified as sensitive places. In certain jurisdictions, lawmakers attempted to ban firearms from public transportation, entertainment venues, restaurants serving alcohol, parks, and many other locations. Gun rights organizations immediately challenged many of those laws, arguing that states were trying to bypass Supreme Court decisions by redefining huge portions of public life as off-limits for lawful carry. And that battle is still happening right now in courts across America. This is why the phrase, "carry anywhere," is legally misleading, even though constitutional protections for carrying firearms have unquestionably expanded in some areas. The Supreme Court's broader message has been that the Second Amendment must be treated like other constitutional rights. Courts are now less willing to accept broad restrictions simply because governments argue they are helpful for public safety. Instead, judges are being asked to examine whether restrictions are historically supported and constitutionally justified. That new framework is having a huge impact. States with strict firearm regulations are facing increasing legal pressure as lawsuits continue challenging permit systems, carry restrictions, licensing requirements, and location-based bans. At the same time, states with already permissive gun laws are seeing fewer changes because their laws already align more closely with the court's direction. The reaction from law enforcement agencies has also been significant. Police departments and legal advisors across multiple states are reviewing policies to determine how these rulings affect enforcement standards. Officers must understand which restrictions remain valid, which are under legal challenge, and how constitutional rulings interact with state law. This creates a complicated legal environment where rules may differ dramatically depending on where someone lives. For example, some states now allow permitless carry under constitutional carry laws, while others still require permits and maintain stricter regulations on where firearms can be carried publicly. Even after Supreme Court decisions, there is no single nationwide carry policy covering all 50 states. And that is important for gun owners to understand. A constitutional ruling may strengthen Second Amendment protections broadly, but state laws still matter enormously. Someone legally carrying in one state may face completely different requirements in another. That is why legal experts consistently warn people to understand their own state's firearm laws before carrying. Social media often oversimplifies these issues. Videos and headlines claiming that all carry restrictions are gone, or that Americans can now carry everywhere, generate attention quickly, but they ignore the reality that constitutional law develops through ongoing court battles, not one instant nationwide transformation. What is true is that the Supreme Court has changed the direction of Second Amendment jurisprudence. Lower courts are now under greater pressure to justify firearm restrictions historically rather than relying primarily on modern policy arguments. This makes it more difficult for governments to defend broad discretionary systems or sweeping restrictions lacking strong constitutional grounding. Gun rights advocates believe this could lead to more successful legal challenges in the future. They argue that many firearm laws passed over the last several decades may not survive under the stricter constitutional approach now favored by the court. Opponents, however, warn that limiting government flexibility could make it harder for states to address public safety concerns related to firearms. They argue that modern conditions differ significantly from historical America and that governments need authority to respond to evolving threats. This disagreement is now shaping one of the biggest constitutional debates in the country, and the effects will likely continue for years. More lawsuits are already being prepared. More state laws are expected to face constitutional review. More judges will be forced to interpret how far the Second Amendment extends under the court's newer framework. That means the legal landscape surrounding firearms remains highly active and constantly evolving. For ordinary Americans, the most important thing is separating facts from exaggeration. No, the Supreme Court did not declare that everyone can carry firearms literally anywhere without restriction. But yes, the court has strengthened constitutional protections for public carry and significantly changed how firearm laws are reviewed by judges. That distinction matters. Because the real story is not about one dramatic moment where all gun laws disappeared overnight. The real story is about a long-term constitutional shift that is gradually reshaping firearm law across the United States. And every new court case could push that transformation even further. Some states will likely continue resisting broader interpretations of the Second Amendment by passing new regulations designed to survive constitutional scrutiny. Gun rights organizations will continue challenging those laws aggressively in federal court. As this legal battle continues, Americans on both sides of the debate are watching closely because the future of firearm regulation may depend heavily on how courts apply the Supreme Court's constitutional framework in upcoming cases. One thing is certain. The national conversation surrounding gun rights is far from over. The Supreme Court has opened a new chapter in Second Amendment law, and its impact is still unfolding in real time across America. If you want continued updates on major gun rights cases, Supreme Court decisions, state responses, and constitutional law changes, subscribe right now and stay informed because the next major ruling could once again reshape the future of firearm rights in the United States.